Hey, 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 it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hope you guys are having an awesome Tuesday and actually staying warm in Dallas, Texas right now. We are about to hit a freeze for the next 3 days. So if you're in Texas, in the Dallas area, please stay warm. So I have not covered this case, but I decided let me go ahead and pull this complaint and read it to you guys and see what's going on. So I don't know if you guys remember the Detroit rapper by the name of Dank Demoss. She actually sued Lyft because the driver refused to let her in the car and pretty much told her that her weight was a problem and drove off. So I was able to get my hands on the complaint so we could see exactly what she is suing for. So this was filed in the Third Circuit Court of Wayne County in Michigan. And let's see. So the parties now, as of right now, obviously she doesn't know who the driver is, and so normally what happens once a complaint is filed and the complaint is sent to the adjuster, then they do their investigation to figure out who the driver was, and then they'll come back and amend the complaint. So as of right now, John Doe is being sued as well as Lyft. Um, Here are the factual allegations. We also know that Defendant Lyft is a ride-sharing company that offers transportation services. Once an individual requests and pays for transportation services from the defendant Lyft assigns a driver to provide transportation. On or about January 18th, 2025, plaintiff paid defendant Lyft for the transportation from her residence in Detroit, Michigan to a football watch party at her cousin's house. After approximately 10 to 15 minutes, defendant John Doe arrived on behalf of defendant Lyft in a Mercedes Benz sedan. As plaintiff attempted to enter the vehicle, defendant John Doe refused to let plaintiff enter his vehicle. Specifically, as plaintiff walked towards the vehicle, defendant John Doe locked the doors to his vehicle and attempted to drive away. Plaintiff was shocked and asked defendant John Doe what he was doing. Defendant John Doe told plaintiff that he could not let her enter his vehicle. Defendant John Doe informed plaintiff that she was too big to get into his car and that he was canceling her ride. Plaintiff repeatedly asked defendant John Doe why he was not letting her get into the vehicle. Defendant John Doe stated that plaintiff could not enter his vehicle because one, she was too big to fit in the back seat, and two, his tires were not capable of supporting plaintiff's weight. Plaintiff informed defendant John Doe that there were plenty of room for her in the back seat and she did not require a bigger car. Defendant John Doe told plaintiff that he had this problem in the past and told plaintiff that overweight individuals must order Lyft XLs. And let me go to the footnote. So it says a Lyft XL is a larger vehicle that can fit up to six passengers. Lyft's website requires that XL rates are a bit higher than standard rates. Defendant John Doe proceeded to cancel the plaintiff's ride and drove off. As a result, plaintiff was unable to attend her cousin's party. As a result of defendant's actions, plaintiff has suffered and will continue to suffer damages, including but not limited to the following: stress, humiliation, embarrassment, outrage, mental anguish, fear and mortification, emotional damages, economic damages, non economic damages, attorney fees and costs, other damages to be discovered through the course of litigation. They're suing, let's see, count one is a violation of Michigan's Elliott Larson Civil Rights Act, public accommodation, a hostile environment. Interesting. At all material times, defendants offered a public accommodation covered by and within the meaning of the Michigan Elliott Larson Civil Rights Act. Plaintiff's weight was at least one factor that made a difference in the defendant's treatment of plaintiff and subjected her to a hostile environment. Defendant's acts and omissions constitute weight harassment and violate plaintiff's rights under the ELCRA by subjecting plaintiff to unwelcome conduct based on her weight. Defendant Lyft, through its agents, representatives, and employees, discriminated against plaintiff based on her weight and acted in accordance with the predisposition. Defendant Lyft, through its agents, representatives, and employees, unlawfully discriminated against plaintiff based on her weight, treated her differently from similarly situated individuals based on weight, and allowed plaintiff to be subject to unlawful harassment based on her weight. Defendant's actions were intentional and in disregard for plaintiff's rights and sensibilities. As a direct proximate cause of defendant's unlawful actions, plaintiff has sustained and continues to sustain injuries and damages. Wherefore, plaintiff respectfully requests that this honorable court enter judgment on plaintiff's claims in a sum that the court or jury find to be fair and just, including attorney fees, costs, and exemplary damages. The second cause of action is let's see, a violation of Michigan's Elliott Larson Civil Rights Act for public accommodation, desperate treatment. At all material times, defendant offered a public accommodation covered by and within the meaning of the Michigan Elliott Larson Civil Rights Act. Let's see, defendant Lyft is vicariously liable for the violation of plaintiff's rights under that particular act. Her weight was a factor that made a difference in the treatment of plaintiff. Defendant Lyft, through its agents and employees or representatives, was predisposed to discriminate on the basis of weight and acted in accordance with the predeposition. Defendant Lyft, through its agents, representatives, and employees, treated plaintiff differently from similarly similarly situated individuals based on the unlawful considerations of weight. Their actions were willful, intentional, and or made in reckless disregard of plaintiff's rights and sensibilities, and so on and so forth. So they are also asking for the court to enter in a judgment on plaintiff's claims in a sum that the court or the jury will find fair and just, including attorney fees, costs, and exemplary damages. So that's all. It's a little bit different because everybody is like, well, he was wrong, and then you have people saying that he wasn't wrong. Um, we do a lot of rideshare cases, but when it comes to personal injury or car wrecks where the client was driving in a Lyft or an Uber, and one thing I do know, if there is any damage to the property, the car, for instance, just depending, some cover the damages in a wreck. If they don't, then the driver is responsible for having their own insurance to ensure that their damages in regards to their car, their property damage, is covered. Now, the John Doe stated that he's been in this situation before where it damaged his vehicle. And I am assuming that Lyft did not, you know, they didn't pay for it. Let's put it that way. So he probably tried to do a claim and it didn't work out. With that being said, now he's cautious, okay? Because you have to understand, some people, that's how they make their living, okay? They do Uber, they do rideshare, so you can't say, well, he needs to find another. It works with his schedule. So if he's being cautious and he doesn't want to go through that again, I do understand why he did what he did. And he just say, hey, just request an Excel. All right. So that's one thing. Now I do understand on the other side that, okay, that is based off of discrimination because, one, you can't just tell somebody that, they can't ride in a car because of their weight. That is discrimination. So it's very interesting to see how this case is going to play out. I tried, well, not tried. I actually went on and tried to do some research to see what the requirements, both Uber and Lyft, when it comes to, property damage caused by the um, the customer. And what it stated is that the customer would be responsible for any damages on the car. So there's a lot of things, there's a lot of factors that play, but there's a lot of gray areas. It's like, okay, who is responsible? If a customer damages your car, okay, the customer is responsible, but is Lyft also going to be responsible? Can the driver go make a claim under Lyft for property damage and they take care of it because the customer damaged the vehicle? That is going to be the biggest question here. But y'all tell me what y'all think in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed and I'm out. Bye.